Great, so welcome back. In United States versus Alvarez, the Supreme Court's most recent and perhaps most definitive decision on lies, free speech, and the law, the court held that the First Amendment forecloses government measures that target falsity and nothing more. In other contexts, however, the Supreme Court has acknowledged that the government may seek to ensure that the stream of information flows cleanly as well as freely. And on this panel, we'll discuss the boundaries between the protected side of that equation and the punishable side of false speech. Our panelists offer related and perhaps overlapping, I think, frameworks for analyzing both the desirability and the constitutionality of the regulation of false speech and lies. And within these frameworks, the panelists examine laws regulating false speech that the courts have routinely upheld, and they explore laws regulating false speech that the courts should perhaps uphold. Each of the panelists will present their papers in turn, and then we'll turn to a discussion, leaving plenty of time for audience questions. So first, I'll introduce our wonderful panelists. We have Helen Norton, University Distinguished Professor and Roth-Gerber Chair in Constitutional Law at the University of Colorado School of Law. Deborah Pearlstein is Professor of Law and Co-Director of the Florsheim Center for Constitutional Democracy at Cardozo School of Law at Yeshiva University. Mark Tushnet is William Nelson Cromwell Professor of Law Emeritus at Harvard Law School. And Eugene Volokh is Gary T. Schwartz Distinguished Professor of Law at UCLA School of Law. So Mark, we'd love to start with you. If you could give a brief presentation of your paper.
Okay. So the way I approach these problems is to distinguish in the first instance between first order justifications for free expression doctrine and second order ones. The first order justifications look to the social value of expression, promoting democracy, the sort of familiar litany. My own view is that the better explanation for first free expression doctrine lies not in assessing whether first order values are more or less promoted by one or another doctrine, but rather to look at second order concerns, which are institutional concerns. That is, suppose we have institutions that are going to have to implement the First Amendment. These include courts, legislatures, administrative agencies, juries, and each one of those institutions has its own set of institutional characteristics, which those characteristics lead them to have, call them different kinds of assessments of the balance among first order interests. And then the second component of the argument, the second order concerns is, and here there's a dialogue between me and Helen Norton and from Eugene's comments earlier, perhaps with him as well. My own view is that the best way to think of the second order institutional characteristics is that all of these institutions are imperfect and they generate risks of error. Everyone will make mistakes of one or another sort when they're processing the things that they're supposed to do. Professor Norton's paper and Eugene's comments earlier substitute the term distrust for risk. I think risk is a better characterization, and we can talk about that if anybody's interested in it. So then you assess what the risks are, and they're going to vary with the institutions and with the nature of the problems at stake. The bottom line on, so this sort of standard arguments about falsehoods are chilling effects arguments that juries may make mistakes in labeling as false something that's actually true. And so you have to define a doctrine that gives some breathing space for falsity in order to ensure that you're not suppressing truth, mistakenly suppressing truth, not maliciously, but mistakenly suppressing truth, and so on. I don't want to develop the argument in detail, but the sort of bottom line of the argument with respect to lies is that the concern about lies is these are falsehoods that are disseminated intentionally or knowing them to be false. Here, the risk is that a decision maker will mistakenly determine that mistakenly determine actually two things, so one of two things, that the statement is false or that it was made knowing it to be false. As I work out the idea, I end up with the conclusion that it should be permissible, contrary to one take on Alvarez, and again, we can talk about this, for government to penalize the dissemination of lies about what I call basic facts, like where the polling place is, or whether the date for voting has been delayed from Tuesday to Wednesday, without having to show that these lies about basic facts actually cause harm. They can simply prohibit, regulate the dissemination of lies. One, I want to note, this is something that I think we have to talk about, and then I'll wind up, that one area of concern with respect to saying there should be restrictions on the government's ability to regulate the dissemination of falsehoods and intentional falsehoods is going to arise in the context of false advertising law, where just work out the details of the court's doctrine. There's a collision course between what the court's been saying about dissemination of lies and the relation between lies and harm and false advertising law. Actually, one last item this occurred to me in the prior session. One of the problems with one of the doctrinal problems with what's happening in connection with concerns about regulation of falsehoods and lies is that assuming that there's some concern here, some valid First Amendment concern that limits the government's ability to regulate the dissemination of falsehoods and lies, working out the doctrinal details is extremely difficult. So in the last panel, sort of the elevation of First Amendment concerns was referred to in connection with Alonis and Alvarez and Citizens United. Well, working out what sort of doctrine you're going to have for threat liability in Alonis or for false advertising in the context of corporate speech. Citizens United is corporate political speech, but corporate speech is commercial speech as well. Working out how you're going to construct a doctrine that makes sense of strong intuitions, at the very least, about proper outcomes. It's really hard. And as I say, I don't think the court has sort of noticed the problems of working out these doctrinal details, but it hasn't yet started to grapple with all of the details. I'll stop with that.
Great, thank you. I'm really excited for the panel to dig into a lot of the second order concerns that you raise in your paper. But Mark, I first wondered if you could just expand on one of the first order claims that you make about regulation of non-intentional falsehoods being valuable because they force listeners to confront their existing beliefs and kind of strengthen those beliefs. But you draw a clear distinction between falsehoods and lies. And so I wondered, how are lies different on that ground?
Yeah, so this is a very complicated argument, and people make it people derive it from Mill, who does talk about the way confronting false, his word is opinions, leads people to a clearer appreciation of their own views. He does, in passing, say something about facts, but it's actually less clear how confronting the falsehood about where Barack Obama was born gives you a clearer appreciation of the fact that he was born in Hawaii. But maybe it does. I mean, I'm willing to concede that there might be some possibility that it does. But where somebody disseminates that, not believing it, that is knowing it to be false, or or bullshitting you about it, that's Harry Frankfurt's term. It's just the effort you have to go through to come to a further appreciation of the fact that Barack Obama was born in Hawaii is just wheel spinning. And it's actually an imposition of a cost on you simply for the purpose of imposing the cost, not to test your appreciation of that fact. There's this economist term, raising rivals costs. It just raises the cost of your holding your own opinion without any further benefit. And that cost, in the economics literature, that cost is stuff that harms you in your other activities that you want to do. So I think even if the Millian argument is very difficult to work out in the context of facts, but even if you work it out in that context, I don't think it carries over for in the case of dissemination of falsehoods by people who believe the things to be false.
Great, thank you. Deborah.
Thanks very much to Carrie and Katie and Genevieve. I'm just delighted to be here. So I came at this project from the perspective and from a background in human rights and democracy, and was looking at these problems and watching sort of the information ecosystem here in the United States from the perspective of, holy cow, this looks an awful lot like techniques from the former Soviet Union, former Soviet Union, indeed Putin, flood the zone of information, make it impossible for the people to tell the difference between truth and falsity, and therefore make democracy, or effectively disable the operation of democracy, right? So I came at this, and notwithstanding the premise of the conference that our focus should be on the particular kind of speech, right? And not just the focus of the conference, but the way the Supreme Court goes about approaching First Amendment speech, which is by identifying particular categories of speech, right? Is the speech false? Is the speech defamatory? Is the speech valuable? Is it not valuable? That instead, my approach, or a more helpful way I find of thinking about whether speech should be regulable or not, is by thinking about it in terms of harms. So the school of folks who say, right, what the question we should be asking in the First Amendment context is, what's the nature, what kinds of social political harms are sufficiently worrisome, are in the Alvarez case, constitutionally cognizable to be worth and necessary to regulate. And that's what my paper is really focused on. It makes, in that sort of realm, I think, maybe two different kinds of contributions. One is a descriptive contribution that says, notwithstanding the fact that, right, I teach this stuff, and the traditional baseline of First Amendment doctrine is something like, speech is not regulable, or essentially never regulable, unless it falls within one of these identified categories of speech, defamation and obscenity, and so forth. And false speech as such is not one of those categories. And so the first question is, what kind of speech do you have? And only if it falls in one of these identifiable categories should we think about it as regulable. my argument is that I think this does not remotely accurately describe the nature of actual First Amendment doctrine. On the contrary, there is, as I think Genevieve was mentioning at the outset, there is an enormous amount of speech, and especially false speech, that we regulate all the time and constitutionally, everything from perjury and impersonating government officials to speech that's disruptive to courtrooms and polling places, to lies by lawyers and judges who are campaigning for election, to candidates running for office and trying to disclaim their authorship or belief in their own campaign messages. I think it's just a grossly oversimplified statement of what the court has actually been doing over the decades. And indeed, from the kind of harms that I'm interested in, it is entirely possible to identify what I would call a democracy harms category of regulable speech, right? What counts as a democracy harm? Well, if you look across the doctrine, I think there are at least three areas of harms that the court has allowed regulation for, right? One is speech that disrupts the actual function of government institutions. So speech not only that disrupts the functions of courtrooms, speech that disrupts the functions of polling places, and makes it impossible for speech that disrupts the function or undermines the function in different ways of executive agencies. And even right speech, for example, in legislative bodies that have their own power. The court recently reaffirmed just a couple of weeks ago, right, to censure their members for speech that is false, right? So at a minimum, in the context of protecting the actual function of our institutions of government, we can regulate all kinds of false speech and do regulate all kinds of false speech all the time. There are also two other categories of democracy harms that we can talk about maybe more, because I think they're much more complex and challenging. But one is the requirement that we maintain, that the First Amendment be interpreted to maintain or allow the maintenance of a marketplace of ideas that is sufficient for the conduct of democracy, so that if you have, through either monopolistic control or other ways, a marketplace of ideas that makes it impossible for people to distinguish the difference between truth and falsehood, right? You have now created or allowed to be created a dysfunctional or indeed non-democratic system of government. And that is something that, whether you think about it in terms of affirmative rights, I don't think you need to, or simply permissive regulation, or permissibility of certain kinds of speech regulation, that's one of the democracy harms that worries about too, and maybe most controversial. And here, I think Eugene and I were having a useful conversation last night. I think it is clear, because it threads throughout many of these cases and all of this doctrine, that a third democracy harm is speech that undermines the maintenance of public faith in democratic institutions. Now, this, when I saw this throughout the doctrine and then wrote it down, I thought, oh my God, I'm a Nazi. Like what, right? It struck me as so fundamentally inconsistent with the sort of Justice Jackson, the government can't prescribe what's, true and false, or prescribe beliefs and so forth. But the more I looked at not only the language in the court's cases, but also the sort of what I would consider first order human rights principles on which these are based, and obviously the British and American tradition in which they grew up, right? This threads throughout. It is both functionally true that democracy does not work without a certain degree of public faith that if I cast a vote, I will have some authorship in the conduct of my government. And in the absence of that belief, that form of government can't work. The court sees this in spades, right? In the absence of belief in the legitimacy of the Supreme Court's opinions, right? It has absolutely no effect. But it's not only the court that requires that kind of public faith. And in fact, one can find cases from campaign finance disclosure rules through no lies in campaigns for public judges, for judicial elections, that a core purpose of the reason those regulations are upheld, those content-based speech regulations prohibiting lies in those particular contexts, are upheld is because they undermine public faith in the conduct of the institution. Okay, so why, having gotten all the way through this, did I conclude maybe I'm not a Nazi yet? I'm right, I'm struggling against the darkness. I think there are two things that this sort of descriptive analysis led me to conclude, right? One was our description, our usual description of First Amendment doctrine, no speech regulation, but for this collection of harms, the collection of named categories of harms, by the way, which are substantially private harms, right? So defamation, harms to personal reputation, incitement to violence, the harm of you getting punched in the face by somebody else, right? Which are inarguably, right, harmful. By pretending that this category of democracy harms is something like, oh, other criminal laws, or right, some sort of other harms to be named later. It substantially deprivileges and indeed discounts the serious nature of the harms that these speech regulations are designed to affect, privileging private harms over public harms in one another way. And the last thing it made me conclude, and I think this brings me into contact more maybe with Helen and Mark's pieces, that the check against this, right, is not to deny that these things aren't harmful, that these lies that harm democracy in certain specific ways are not regulable. They are regulable. We regulate them every day, but to insist that we have a much more rigorous, meaningful, and indeed empirical check as a way of analysis, right? The means ends test in a way that is vastly less ad hoc than the court has ever sort of applied it. That is based on things like record evidence and empirical information as a constraint on the way that institutions, which we should distrust and also are filled with error, make decisions about whether or not some particular speech regulation will actually succeed in preventing or even mitigating the specific identified democracy harm that we're setting out to regulate. If you look at sort of, and this is the last piece I'll make and I'll stop talking. If you look at, right, one of the factual premises of the last century-ish of Supreme Court jurisprudence, that more speech is always better, right? That this will, that from more speech, truth will out, right? If the internet has put the lie to anything, it is both empirically and in other ways. That's not the way it works, right? That is in fact a false, that is fake news in First Amendment speech, right? That's not the way the information ecosystem works. And we should be able to insist that our decision-making institutions, whether it's the court or administrative agencies that are policing these rules, or whichever the institutional body that's acting here, actually makes contact from a First Amendment perspective with that reality of information, and that is the essential check, should be the essential check on speech regulation in this space.
Thanks. So one thing I love about your paper is you kind of flip the script on the traditional democratic theory of the First Amendment, where we are supposed to have absolute protection for political speech because that's the only way that we can enable an informed electorate that gives rise to true consent of the governed, and show that perhaps the First Amendment is operating at odds of ensuring an informed electorate. And I think Helen offers a helpful way of thinking through the situations in which we can and cannot trust the government to act in its own self-preservation. So Helen, over to you.
Thanks, Carrie and Genevieve and Katie and the whole Knight Institute team for making this terrific event possible. So I'm interested in exploring the relationship between negative First Amendment theory and the government's regulation of lies. And by negative free speech theory, I'm talking about the idea that the Constitution protects speech, not necessarily because speech is all that worthy or valuable, or not only because speech is worthy or valuable, but instead because the government is so dangerous in its potential for overreach or regulatory abuse at the expense of both speakers and listeners. And here I contrast negative free speech theory to affirmative free speech theory, which includes the idea that free speech is good for any of a variety of reasons: democratic self-governance, or discovery of truth, or as President Bollinger has argued, the development of positive character traits like tolerance. Negative theory is about a negative value, distrust, although I'm open to Mark's suggestion of risk assessment as a replacement there. But I'm relying primarily on political science theory that speaks of this as a matter of distrust. So United States versus Alvarez is an example of negative theory applied. All of the parties in that case, including Mr. Alvarez's lawyer, the liar's lawyer, agreed that the Stolen Valor Act neither punished nor chilled any valuable speech. But the plurality in the concurring opinions, 6 justices at the time, nevertheless struck down the act, relying solely on negative theory, a focus on constraining the government's potential for danger, its potential for overreach. So again, negative theory is about a negative value, distrust of the government. And because the government gives us plenty of reason to distrust it, negative theory packs a lot of power. But it can have, negative theory can have a broad or a narrow scope, depending on when and why we distrust the government. And in my view, negative theory, like any theory, needs limiting principles that help us understand when the government's regulation of expression is and isn't justifiable. Because without limits, negative theory would always counsel against any government regulation of speech, even though a completely absolutist approach is unworkable. So while negative theory acts as an important guardrail on the government, I think that negative theory warrants some guardrails of its own. So I'm here for these purposes, I'm focusing on negative theory's implications for the government's regulation of lies. But I note that negative theory increasingly dominates the contemporary court's approach to a wide range of other First Amendment problems. And there too, in my view, reflexive or unconsidered reliance on negative theory invites us to look hard for some limiting principles. I'm thinking of Reed versus Gilbert, for example, where the majority relied purely on negative theory when it announced that it would apply strict scrutiny anytime the government regulates speech on the basis of content, regardless of context. And the majority, this is the Clarence Thomas opinion, expressly relied on negative theory, a fear of future government abuse, even though there wasn't evidence of government abuse in this case to justify the sweeping rule. And Justice Kagan and Justice Breyer, in separate concurring opinions, push back on this idea. They argue that negative theory is inappropriate absent indications of the government's self-interest or intolerance, indications that they define to include things like the government's viewpoint-based discrimination or the government's erasure of certain topics from public discourse. So the primary point of my paper is to urge that we be thoughtful rather than reflexive in applying negative theory. In other words, to urge that we take care to consider and explain why and when we distrust some government actors more than others, why and when we distrust the government more than private actors, and vice versa. So what would this require? My plea to be more thoughtful about when and why to apply negative theory. So here again, I'm relying on political scientists like Russell Hardin, who observe that our willingness to trust any actor, including the government, generally relies on our inductive assessment of the actor's motives and competence. In other words, our experience with that actor. So under this view, to say that we distrust the government to regulate in a certain area means that our experience leads us to believe either that the government does not have the right intentions or motives, and or that the government doesn't have the competence to regulate in that setting. And relatedly, trust and distrust are both episodic and comparative notions. Whether we trust or distrust the government or any other actor depends on when we're asked. We would be unwise to always trust or always distrust, and also depends on compared to whom. If we don't trust the government, who are we then trusting? And does that make sense? So recognizing that distrust is an inductive concept based on our experience with the government's or any other actor's motives and competence suggests to me at least the value of looking for factors, we might call them triggers, that would increase our distrust of the government in any given regulatory setting, as well as factors, and here we might call them contraindications, that would ameliorate our distrust. Now, we can imagine all sorts of different specific factors, specific triggers and contraindications. In the interest of time, and I very much look forward to continuing this conversation on this panel and for the rest of the day, my own view more generally is that negative theory should pack the most power where our experience indicates that the government may be self-interested or intolerant, such that we distrust its motives, or where it may be clumsy, right, as can be the case where it draws malleable lines, absent sufficient information or expertise, or where the government's decision makers might be particularly vulnerable to cognitive or emotional biases, or where the government's discretion is unbounded. And then conversely, negative theory, in my view, should carry less weight in settings where the government's discretion is limited, where we don't see evidence or suspect evidence of its self-interested or intolerant motive, or this is the comparative factor, where our experience leaves us even more distrustful of powerful and unrestrained private actors that might be the subject of the government's regulation. How can we make this more granular? Well, I think both Mark and Eugene actually suggested a couple of possibilities, right? Mark is interested in the notion that there are different regulatory designs that should trigger more or less distrust of the government regulator. And Eugene is interested, among other things, in the idea that we can be, our trust or distrust of the government may turn in part on the availability of effective alternative truth-seeking institutions that could counter a falsehood in the area. And I think those are both very productive ideas. I would also say the court's doctrine, Alvarez in particular, is a search. And Mark commented quite rightly on the difficulty of this doctrinal search. And I would say the court is at the beginning of its learning curve, or at least I hope it's at the beginning of its learning curve. But you could understand Alvarez and the plurality and the concurring opinions about trying to identify limits on negative theory, right? And the breadth and the malleability of the government's regulatory regime triggered distrust. And on the other hand, when the government could tether its regulation to harm of sufficient, and this is the big debate, sufficient gravity or likelihood of harm, then that ameliorated our distrust. And Deborah is interested in these sorts of questions about how we can accurately capture very significant harms while at the same time limiting the government's capacity for overreach.
Okay, thank you, Helen. So as you emphasize, the institutional analysis is highly comparative in nature, and Eugene identifies a few other institutions to which we might compare the government when it comes to truth seeking.
Thanks. Thanks very much for having me here on this panel of this conference. Tremendously important subject, tremendously difficult. I wore my question mark cufflinks to this conference to remind me that's I don't know what the right answer is. And also, I should also flag, James Weinstein and I filed an amicus brief in the Alvarez case on supporting what ultimately proved to be the dissenting position. We thought that the Stolen Valor Act should be upheld. So I'm out of step with lots of people in lots of ways, including the Supreme Court. So that further casts doubt in my mind on my ability to kind of predict what the court will do, or even make arguments that I think are likely to be viable in our legal system. But in this respect, I wanted to kind of talk about something that the court has said that I think are probably correct and reflect on why that might be so. So I wanted to start by a little bit of history and tying into one thing that Deborah said, at least in the first maybe 2/3 of her talk. I don't think she's at all a Nazi for the 2/3 of the talk. I think she's a federalist in the sense of a supporter, at least of this one particular point, of the party that was in charge during the Adams administration, that was responsible for the Sedition Act of 1798, which the supporters stressed was a vast improvement over past seditious libel law. It was limited, at least as to one provision, there are other provisions too, to false and malicious statements. Basically, one might at least interpret that, although maybe it's a little historical, as basically lies about factual questions. And let me quote something that Justice Iredell said, and this was alluded to in an earlier panel, in I think a 1799 charge to a grand jury. Men who are at a distance from the source of information must rely on the accounts they receive from others. If those accounts are false, there cannot be proof against their influence, nor is it possible to calculate the combined effect of innumerable falsehoods told day by day. Such being unquestionably the case, can it be tolerated in any civilized society that any should be permitted with impunity to tell falsehoods to the people with an express intention to deceive them and lead them into discontent, if not into insurrection, which is so apt to follow? And he goes on to say that if anything, in a republic, lies are even more in need of punishment, including lies about the government and its processes, than in a monarchy, because so much in a republic depends on the confidence of the people. That's very similar, except for the slightly archaic language, to a lot of what we've been hearing today. Not today, but these days generally, about the perils of fake news, which I think is quite accurate. I don't think there's anything that the factual description that he says is wrong, nor anything that I would disagree with Deborah on in her version of this. And yet, and let me shift a little bit to the doctrine here, one of the things we know from the court and from New York Times v. Sullivan, the lesser known holding of New York Times v. Sullivan, is that there are certain lies that are protected, in particular lies about the government. That libels against the government either cannot be prosecuted or they can't be sued over. Occasionally you see government entities, almost all lower level ones who are not very well advised, sue for libeling the city of San Bernardino. Well, no, you can't do that. Why? Even though Justice Iredell's point, I think, is quite forceful. Well, we'll get to perhaps the why a little bit, but it's important, I think, to recognize that lies about the government, under at least a unanimous at the time, maybe not entirely agreed with, although maybe even Justices Gorsuch and Thomas, who criticized the holding of New York Times v. Sullivan as to public officials, might agree with it as to the government. But in any event, it's pretty broadly agreed that lies about the government are categorically protected. Let me turn back to another case from now not 200 plus years ago, but a little over 100 years ago. And it's Schaefer v. United States. And it had to do with the prosecution of somebody who's writing in a German language newspaper about World War I, during World War I, in a way that was somewhat sympathetic to Germany, which of course is on the other side. And he was prosecuted for basically false news reports. And one of this had to do with a mistranslation. And Brandeis dwelled on it. I think Brandeis was in fact a fluent German speaker, so he was quite confident about the nature and the magnitude of the mistranslation. That in a quote from Senator La Follette, the prediction of bread lines was translated into German as bread riots. That's what was a specific detail. But a broader point was, in fact, that the majority said, you know, these were lies, these were false reports, because they were saying that the war was really just foisted on an unwilling American public, and we all know that's not the case. So one of the things that we see looking at cases like Schaefer and looking at some of the Sedition Act cases, my favorite is one called U.S. v. Cooper, where Justice Chase also instructed the jury in that case about the importance for democracy of prohibiting lies about the government. But it turns out, and I don't have the time to get into the details, that if you look at the things that Cooper was accused of, today we'd all agree that it was opinion. But in the era, in the atmosphere of the time, these were seen as lies. Maybe because the fact-opinion line was not as well understood then as it is now. Although even today, if you look at court cases, they struggle a lot with it. But I think also in part because it's very easy for people to label fake news and label as lies things that really are questions of judgment. And we see that in a lot of the criticisms, for example, about COVID misinformation. I think there is a lot of COVID misinformation. I'm unhappy with it. But a lot of it is not, even the one that is labeled lies, is not lies in the sense of, well, factually speaking, only 300 people have died from COVID. Rather, it's, well, what about the vaccine? Can we be sure that it's really safe? Yes, scientists tell us this, but do we really trust the scientists? A lot of these are, you know, I think on balance, I do trust the scientists. There was a great line from someone talking about someone who was a patient whose liver transplant was jeopardized because he wouldn't get vaccinated. And they're saying it's kind of ironic. This person doesn't trust medicine about vaccines, but he's willing to have them transplant a liver into him. I sympathize with the desire to try to clamp down on that, but that's really a desire to try to clamp down on opinion and not just false statement of fact. So far I've said two things and I want to say two more and then we'll close. One is there's a long history of this. And the second related thing is that it is a history that, among other things, shows that restrictions on lies end up not only restricting, as Mark points out, as a practical matter, may restrict sincere errors, and sometimes may restrict the truth, but often restrict opinion as well. Related to that, let me just mention doctrinally one more category of things that are clearly protected, at least according to the concurrence and the dissent in Alvarez, but I think the majority, plurality, excuse me, would have agreed too. And that is lies about social science. I think it would be extended to physical science, history, art, religion, philosophy, and such. So there is a sense among many justices, possibly all justices, that those are things just like lies about the government that we shouldn't be restricting. At the same time, there's no doubt, and I think Deborah was quite right in this, and Helen and Marco, all of us agree, there's a huge category of lies that are not protected. For example, libel. For example, fraud, including not purely commercial fraud, but fraudulent charitable solicitations. Charitable solicitations viewed as fully protected, but not if they're fraudulent. Perjury and the like. And there's, of course, an interesting category of things that are, for which this is unresolved. The main important one is lies during an election, not just lies about the mechanics of an election, which I do think would be regulable, and the court has hinted at that, but lies during an election campaign. A couple of early cases upheld those laws. Some more recent cases, all lower court cases, struck them down. So there is this uncertainty in the middle, but also clear agreement that some kinds of lies are protected and some are not. So then the question is why? And let me just close with this. So why does Alvarez, or why do at least 5 justices in Alvarez agree that, for example, lies about social science and history and the like are fully protected? So one thing you see is it's said to be perilous to allow the government to make these decisions, very much along the lines of what Helen is saying. I think that's absolutely right. Another thing is tied into Mark's point about Mill, that it may be valuable to allow even falsehoods. And maybe even if we don't want to allow lies, maybe inevitably, or maybe we need to allow them in order to allow sincere falsehoods because of the risk of error. But it's important to allow falsehoods in certain processes. There's actual value to them. One question is what? So what I think is going on there, well, while I got to acknowledge that Alvarez doesn't talk about it, is a sense of comparative institutional reliability. So one question you might ask is, why is it that in an ordinary libel case, and let's look at it as a private figure libel case, nobody talks about the marketplace of ideas being the best solution? By the way, I should stress, Holmes and Brandeis didn't say marketplace of ideas is a perfect solution. It said it is, it's the best solution, best of the alternatives. Likewise, good counsels are a fitting remedy, not a perfect remedy, but a fitting remedy for bad counsels. Why? I think what's going on there, I think if we ask, like, let's say a historian about, well, shouldn't there be a jury trial on this question about what's true or bad or false history? The historian will say, that's ridiculous. Juries are going to do a really bad job of figuring that out. Well, what if we allow judges who at least kind of, they have advanced educations and have the leisure to sort of think through these things? No, that's awful. We've got a process, however imperfect, for trying to reach the truth, although always an iterative process. There's always the possibility of a better, more true truth out there. And that is the academic process, and academic writ large, not just people who are members of university faculties, but also interested lay people, journalists, and so on and so forth. Likewise, I think if you press people as to why you can't have persecutions for libel against the government, the theory is, the government, if you lie about the government is certainly going to speak up a lot. It's got a lot of incentive to speak. And presumably there'll be journalists who are talking about it. None of that is perfect, but it's better than having judges and juries decide whether some statement about the government is false. And on the other hand, with regard to libel, imagine you say, well, to someone who's suing for libel, well, why don't we just have kind of a long-term iterative process to decide whether or not you indeed had your hand in the petty cash, which is what you were accused of doing. That seems kind of ridiculous because nobody's going to come to this person's side. This person doesn't have the resources and nobody else has the interest and incentive to really do that. In a way that I think if there are lies about history or social science or such, at the very least, there'll be a lot of other voices in the discussion, even if maybe foolishly people will fail to heed them. The last thing I want to close on is this is of course an empirical judgment. And it suggests that it ties well into Deborah's point that, well, maybe we should have empirical judgment. Maybe we should really have social science evidence rather than just our gut feels about what's a better process. I got to say, though, I can't say I'm wild about the prospect of judges sort of saying, well, this study has said that counter speech is an adequate remedy here, so speech is protected there, but here the study has said counter speech is an ineffective remedy, so we're going to find it, allow the speech to be restricted. you know, so a scientist colleague of mine, every so often I talk about various science scandals, says the problem is scientists are people and people can be jerks and people can be fools and people can be biased. We hear a lot about the replication crisis in social science. I don't think it means all social science is nonsense, but it makes it hard to sort the nonsense from the sense, or perhaps the varying degrees of sense. Also, we have to admit, various social science institutions are politically quite skewed. Now, it may be because Democrats are smarter than Republicans or better educated than Republicans in various ways, or they just have the right ideas. So, you know, people say that. I don't think that's right, but that could be true. But one way or the other, even if they're very well educated and very sincere, they're still people. And if indeed you have institutions that are dominated by one particular set of ideological attitudes, just human nature being what it is, we can foresee that the results aren't going to be great. Again, maybe a comparative matter. Maybe they're better than our gut feel. Maybe we should go with it. But that's my concern. So that I close.
Well, thank you all so much. I want to focus kind of first on a key, I would call it maybe a provocation, but at least contribution in Mark's paper that draws upon two distinctions that are core to the doctrine. So the first being the distinction between fact and opinion, and the second being the distinction between kind of intentional lies and unintentional falsehoods. And I wonder if these collapse a little bit in the context of what you term epistemic disagreement. So we have, you know, today, perhaps not unprecedented, but certainly very pointed disagreement over the sources of authority that we all draw upon. And I think you suggest that in these situations, because institutions like courts and juries and the government writ large perhaps might misidentify a lie as intentional, or a falsehood rather, as intentional versus unintentional, that we should be very wary of empowering the government to regulate in those circumstances. At the same time, I wonder, really going to Deborah's paper, whether these are exactly the kinds of falsehoods that people are most interested in regulating today, whether these are the kinds of falsehoods that we deem most harmful to democracy. And so where does that leave us, you know, pulling in both Helen and Eugene in terms of the concerns that we might have about empowering the government to regulate this kind of information, you know, at the end of the day. So maybe Mark, I'll go to you first, if you could expand on this point in your paper.
Yeah, so the way I'm thinking about this in the context of today's conversation is why I prefer to formulate things in terms of risks rather than trust. And here I have to say, I come at the issue of trust in government as someone whose political formation occurred in the 1960s. And I would not say that I, as a general matter, trust the government. Okay, now, sometimes yes, sometimes no, but it's all, you know, it's highly contingent in some ways, in the way that Helen suggested towards the end of her presentation. So and part of this is concern about, okay, so my COVID paper is called Trust the Science, but Do Your Own Research, right? You know, scientists are, it's not that they're personally biased. The structure of science has a certain kind of tilt to it, which has some kind of, it's some kind of political valence. And if that's so, then epistemic disagreement is political disagreement. The disagreement over who to trust is a disagreement about where you stand on a political spectrum. And so I am, you know, because I don't think it's, because I'm distrustful of the government's, of various government institutions. I do want to differentiate among them, but you know, the shorthand is I'm skeptical about the ability of governments to take positions on fundamentally political matters, and therefore I do want to keep its ability to regulate in this context as narrow as possible. So, the on the fact opinion distinction, I come out, it's not as clear in the paper as I'm about to say it, but I think it's there in saying that the Holocaust lie is an opinion, not a disagreement. Whatever his name is David or whatever. He's not disseminating falsehoods when he says the Holocaust didn't happen in the way people say it happened. I think that's an opinion and should be protected as such. That's why, yeah, I have to say my category of basic facts is not, I'm not wild about that either. I mean, voting on Wednesday rather than on Tuesday, I mean, that one's pretty straightforward for me. I confess, I think that I got the Congressional Medal of Honor is a lie about a basic fact. I have a defense of the Alvarez opinion. It's embedded in a footnote where I say the government's position led the court to where it went. If the government had taken a different view of how to present its case, it might, who knows if they could have prevailed, but okay. So I guess the one last thing on the issue of trust and epistemic disagreement is I want to channel some aspects of Eugene, at least in an earlier incarnation. I'm pretty sure he probably still believes this. It's not clear to me, again, considering various institutions, why we should distrust institutions with respect to their ability to do stuff regulating speech compared to their ability to do stuff regulating other stuff. I mean, that's Eugene's libertarianism. Or Coase had this point early on. Just not clear to me why, with respect to false statements about commercial products that lead to confusion, but don't lead to different consumer choices. I mean, that's this is the other Tushnet speaking here, but it's not clear to me why there's any problem with regulating that sort of stuff. Okay, I'll just stop there.
Maybe I'll ask Helen to join now. So you do offer a rubric for thinking about instances in which we would distrust the government, focusing on instances where the government may be acting out of self-interest or intolerance or incompetence. And with respect to this realm of false statements where there is substantial disagreement about what is true and what sources of knowledge we could consult to determine what's true, how would the negative theory with the limits that you introduce apply?
Yeah, so this is sort of how I think about the question of why does the Constitution ever protect falsehoods? And I think there are three possible answers. One possibility is that some falsehoods are actually affirmatively valuable, right? And Alan Chen this afternoon is going to talk about a universe of falsehoods that might be affirmatively valuable. And I think the fact opinion distinction does work there, that opinions are more valuable from a First Amendment perspective than false statements of fact. A second possible answer to that question is we sometimes protect falsehoods because permitting their regulation in certain circumstances would chill valuable speech, right? And intent requirements, right? A culpable mental state, malice, reckless indifference tries to cure for that particular problem. And then the third, and this is the focus of my paper, is lots of times the Constitution protects falsehoods not because they're valuable, not because the regulation is chilling any valuable speech, but because we don't trust the government in this particular realm. So wrestling with that, I think, comes back to this question of harm. I think that explains the court's sort of lurching to try to figure out whether and when it's distrustful of the government. And Deborah is interested in this as well. And I'll just flag a couple of things. Eugene has talked about the sort of the 20th century dawn of our understanding of the First Amendment. And in part, it was a large part, it was a reaction to the fact that we could see how the government was overestimating, exaggerating harm in lots of contexts. True. it's also true, and Fred Schauer is among the folks who've identified this, is that actually speech, including lies, are often quite harmful, that they are quite harmful. And that Fred has observed as a matter of doctrine, he has concerns about some of the doctrine because he thinks that courts and commentators, in order to justify invalidating a regulation on First Amendment grounds, discount the actual harm of the speech, right? And I think, Deborah's interested in this, and I'm interested in Sue's actually surfacing the harm of the speech without ignoring the fact that we should still really be concerned about the harm of the regulation in terms of negative theory. I have more to say about this, but I'll stop for now.
Yeah, Deborah, I want to let you jump in here.
Excuse me. I just got tested. I don't have COVID. I apologize for the cough. Yeah, I guess I'd like to say a couple of things. And first of all, it's wonderfully rich. So on the position that, right, the government lacks a competence to regulate and the government can't be trusted to regulate. Yes, all of the above. However, the government regulates the truth and falsity of speech every day, all the time, as we speak. And it does that in judges and juries do that in courtrooms, and administrative agencies do that all the time, and prosecutors make that assessment. Is this guy telling me the truth or not, all the time? And legislatures do that all the time. And so part of what I think frustrates me about the descriptive nature of our sort of First Amendment story that we tell is the notion that this is not happening as it is, right? So the question is, not is this happening, but how do we constrain the government? How do we cabin that decision? How do we, limit the sort of errors and the distrust and so forth? And this is a question that plagues, right, every field of law, administrative law, national security law, and take your pick. And so we have a suite of constraint mechanisms that we have developed in various places, none of which are ideal. But in my view, in this context, right, we let 1,000 flowers bloom because they all have advantages. So, and would that Federalist were the worst thing I were ever called, but thank you. So the Sedition Act, the original one, right, is a terrible law, among other reasons, because it is grossly overbroad, right? One of the key constraints on government power is textual narrowness, limit the scope of the power. So one of the reasons why none of us would object, I take it, to an election rule that says, it's a crime to say the election is on Wednesday when it's actually on Tuesday, or the equivalent of that, is both because it is simple enough, straightforward enough, limited enough that is the kind of decision which we would trust government. But limiting sort of textual limits on the scope of power is only one, right? There are process limits. The Administrative Procedure Act is filled with versions of process limits. Who signed off on this? How much evidence did you consider? What, the like. There are, and this is, sort of the key focus of my paper, information limits. Unless you can show X, Y, or Z, or there is record evidence of the following, right? You cannot act in this way. There are, of course, political accountability limits. Those, I think, are probably least relevant and most destructive in the First Amendment context, but we can talk about that. And then there are different ways of creating sort of incentives and motives in the particular political actor, government actor who is charged with making the decision that can constrain or guide their decisions in different ways. So we have this sort of off-the-shelf array of, gee, if we were to acknowledge that we are actually already in the business of truth and lie regulation all the time, we might be able to think more constructively about which is the best and how could we do this in a better job. But until we get past this sort of, oh, well, the government can't make these decisions, sort of flatline, I think it's been really hard. I think the First Amendment field, more than others in which I sort of more commonly operate, has been atrophied on this question of which constraints might work here, because we haven't quite gotten past the initial step of, oh my God, the government is in this business.
Yeah, so I think it seems to me, so basically you're arguing that we should recognize that the democracy harms that you identify, and particularly the government's interest in ensuring or kind of preventing people from undermining public confidence in democracy itself, should suffice to get us to step 2 of the analysis, of the strict scrutiny analysis. So we can recognize that there's indeed a compelling government interest in ensuring the government's kind of ability to continue on in the democratic tradition. But then we look hard to whether or not the government has narrowly tailored the proposed regulation in the service of that interest. And just coming back to you, Helen, quickly, is that a fair kind of gloss on the way that negative theory could apply? That placing the emphasis on the strict scrutiny analysis could kind of account for the distrust that we might have in government in certain instances?
Yeah, that's certainly one way to do it. Another way to do it is what Justice Breyer proposed in his concurring opinion in Alvarez, which was instead, of course, intermediate scrutiny, right? That he thought he was. The thing that I like about his proposal is that he's not pretending that hard problems are easy. He's saying this is very hard. Lies can be very harmful, and the government's regulation can be very harmful, and that we should be transparent about the fact that we are and should be balancing. So that's another way to do it. I think Deborah actually identified another possibility in her paper, which is the possibility that some of these lies are sufficiently harmful to the integrity of democracy that we could put them in a category of unprotected or less protected speech altogether. Now, all of those choices also shed some light on your comparative trust and distrust of different government actors, right? Justice Breyer, with his comfort with balancing tests, is telling us a lot about his trust of judges, and folks who reject that and prefer bright line rules are telling us something about their distrust of judges.
Great. Sure, Mark, and then to Eugene.
So I've a bunch of ideas about the idea of harm and trust. So the first one, just a suggestion to Deborah, which is you're right in saying that the harms that the court has mostly identified are private law harms. There's at least an argument that Spokio and TransUnion say that's constitutionally required, that you have to find something like a private harm for there to be a constitutionally cognizable harm in the first place. And so part of your project might be to figure out how you can analogize these democracy harms to private harms in a way that would satisfy Spokio kinds of ideas. So second time it's happened. I don't think there's anything wrong in the sense that I think it's politically desirable under many circumstances for people to lose faith, to stop being trustful of the government in place, disseminating ideas that say the government is not to be trusted, the government in place is not to be trusted. I'm basically down with that. And so I don't think that I would not categorize that in general terms as a harm. Sometimes it's wrong, but Ronald Reagan was wrong about a lot of things, and I didn't think his speech should be suppressed. Okay, and then finally, and this is something that Helen just touched on, I didn't want to be specific about, which is the speech, this is Fred Schauer's point, the only way to think about speech regulation is to start with the proposition that governments regulate speech because political actors think that speech is harmful. So there's, all kinds of harms out there. The more you proliferate the harms that count, the more, just short circuit the argument, the more you're ending up trusting judges to get the answers right. And one argument for the limited categories that Deborah started with is that given various structures of institutions in the judiciary, the best way to get the best set of outcomes is not to try to get the best outcome in every case, but to say, look, as a categorical matter, most of the time we're going to get it right. If we apply these rules, we'll get some things wrong. Some things will fall outside the scope of the rules, and that's regrettable. But if we try to build them in, things are going to get worse. I have called these third order concerns, that is about the concerns about the structure of doctrine. And the idea is that these limited categories are the best we can do given the institutional characteristics of our judicial system. I'm not, I don't want to say, I actually think that's probably right, but I don't want to argue for it here. Just want to note that there is an argument that sounds in the register of distrust or risk for the limited categories approach that Deborah started out with.
Yeah, Deborah, did you want to respond to that?
Yeah, just on the point, so this is wonderful and helpful. And this Spokeo TransUnion one is part of a long conversation, so that's great. But I did want to respond to the speech that undermines faith in government piece, because of all the categories I described of democracy harms, right? I say in the paper, and I hope you said here, right? I think this is the most complex and the most worrisome and the most limited. But I do want to be clear about what I'm talking about, right? So I am 100%, I agree that criticism of the government, right? I made a career on suing them and telling them they were doing things that were illegal. Okay, maybe not a whole career, but like a piece of one. Right, absolutely. And that is core protected speech. And to the extent that that undermines faith in the government, that has to be okay, right? So that's not, so when we say undermines faith in the government, it doesn't mean give people the impression the government is doing a bad job or something wrong or whatever. That is the core part of what the First Amendment is meant to protect. It is rather structural faith in the government, right? So not any particular leaders or instantiation of the government, but so, in the campaign finance, the justification for certain kinds of campaign finance regulations, certainly the early ones, was not just you're going to disable government functions if you allow bribery, but that if people believe their legislators are being bought, right, they won't believe that they in fact have voice, a say over their government. Or more recently, right, the court upholds the statute that prohibits very specific limited kinds of lies in judicial campaigns, not because it will make you feel bad about that judge or a particular set of judicial decisions, but because people won't believe that the judiciary is capable of or does operate with anything like, independent judgment and integrity and discretion, and the sort of structural characteristics that define the function of that branch of government. And I think it's possible, although, right, this is complicated and requires a lot more, I think it's possible to distinguish those things. But that's what I'm saying.
So I'm sorry, can I, a terminological point that opens up, I think, real analytic issues. I think you want to distinguish between speech that undermines confidence or trust in the government in place from speech that undermines confidence or trust in government as such.
Yeah.
Okay. And then the question is, it's either doctrinal or analytical or institutional, is can we design formulations of that distinction that are implementable by the actual institutions that would be called upon to implement them. And I frankly am very skeptical about the ability to do that because this goes back to my risk analysis. There are structural reasons to think that there's a fairly high risk that all of the institutions available will misclassify criticism of the government in place as criticism of government as such. This actually, I want to say, connects to Genevieve's larger project about the positive value of the First Amendment, but that's another longer conversation.
Yeah.
So I think Mark and I have this left-right coalition against the center here. Pleased to see this. So I just want to get a little more concrete about these points about the constitutional protection for things that cause distrust in government, including lies that cause distrust in government. So there's no doubt the large rationale for example, campaign finance disclosures and also limits for campaign contributions is the concern that allowing them will cause distrust of government because they will cause a perception that the government is being bribed in a sense, or at least a higher perception. That is to say, if you could have completely confidential contributions or if you could have unlimited contributions. It is also true that you can limit even further campaign solicitations by judges. I think the judicial speech case from the Supreme Court had to do not with lies by judges, but campaign solicitations. Though there was a Michigan case, I think, called In Re Chmuro that allowed certain restrictions on falsehoods in campaigns by judges. On the other hand, let's imagine that Congress were to say, you know, we really care about trust in government. So we're going to make it a crime to allege that some government action is the result of bribery. Now, to be sure, if you falsely allege that a particular person is committing, or excuse me, a particular politician was bribed, that is actually potentially liable. I mean, if it's knowing falsehood, it's liable. It could be criminal libel as well. But let's set aside this libel category, although an interesting question whether we should, but for now, let's do that. And let's say there was such a law. Or let's say there was a law that said, because it's so important to have trust in the judicial system, see Williams, Yulee versus Florida Bar, which says that's a reason to restrict certain kinds of fundraising practices by judicial candidates. It will be a crime to allege that a judicial decision was the product of a bribe. And again, let's assume that this was that it extended also to things that don't specifically mention particular people. I think both of those laws, the hypothetical laws, would be unconstitutional, because it's not just that there is some sufficiently compelling interest in preserving faith in government. It's that you can, and it's not just that the laws are narrow, like the laws having to do with the mechanics of government, of elections, which I agree should be upheld, because some of the laws that I'm describing could be viewed as narrow too. They don't ban all lies. They only ban lies about the government decisions being the products of bribery, let's say. It's that I think we have more confidence in the government's ability to be able to say, look, you know, he said the election was going to be on Wednesday. The election is clearly on Tuesday. There's no dispute about it. You don't have all of these complications about whom you trust on that. It is perfectly well settled. And there's every reason to think, therefore, that it is an outright lie. That's something I think we can tolerate the government doing. I don't think we would say the same with regard to saying, well, you know, yeah, you heard that there was a bribe. Bribes do indeed happen sometimes, but we think you're lying. And the last thing I want to say is Justice Breyer does have this very balancing approach to free speech. I don't much care for it for the usual reasons people don't care for balancing approaches. But even Justice Breyer, who would have a lot of toleration for punishing certain kinds of lies, even he agrees with Justice Alito's dissent that there should be essentially categorical protection for lies about history, social science, that list. He quotes it more or less verbatim. So I think there too, it's not just a question of what the government interest is. It's not just a question of how narrow in the sense of just what how much of a scope the law has. It's whether the law deals with very narrow questions that are easily provable true or false, or with broader issues. So that's my thought.
All right, oh, we need to kick it to audience questions. So if you do have a question, please remember to turn your mic on. Yeah, we'll go to Francesca and Jen.
Thanks. So I want to ask really for anyone, although it probably touches most on what Mark and Helen have said so far, about everyone really has talked about trust, faith, confidence in government as a general term. And I'd like to press more on like what is government and who are the relevant actors that we're really thinking about, what factors should influence the trust, faith, confidence, distrust in the government. So a couple examples, Congress has been mentioned, judges have been mentioned, but of course, in two different capacities, judges in control of their courtroom and falsehoods in the courtroom, judges in control of reviewing statutes that address falsehoods. Something that hasn't been mentioned is public school teachers, which clearly regulate falsehoods in the classroom all the time, not just falsehoods of fact, 2 + 2 = 5, but to use Mark's example, if there was a student who wanted to argue against the Holocaust, I think teachers would, basically say, no, you are historically wrong. So that is not an opinion in the classroom. Law enforcement works with social media companies often to suggest what speech should stay up, come down, and that is a form of government pressure on free speech. Last example, an individual such as the President of the United States saying that someone's speech or institution's speech is false, is fake news, that kind of pressure on that news organization's or that individual's free speech, saying so that the pressure coming from multiple areas in terms of how to regulate falsehoods. How should we think about all these different entities, and there are more, in terms of how much confidence we have? Again, I'll throw out 3 factors that I think you've mentioned. How transparent is the entity? How populist is the entity? Although I think that works in both directions, and I'd be curious, like, if that's a pro or a con. And same thing, expertise. Is that a pro or a con in terms of the trust, faith, confidence that we should have?
Thank you, Francesca. It's a terrific question. And I think it really helps emphasize something that I'm very interested in, is that trust and distrust have to necessarily be both comparative and episodic. So when we talk about whether or not we trust or distrust the government, you are saying which government, right? Because there's so many governments, and we should always ask that. It's not that the answer to whether or not we trust or distrust the government can never be yes or no. It has to be which government at what time, what's going on. We have to be, I think, very granular if we're going to do this seriously. And I very much appreciate the fact that you're thinking hard about what sort of, I've called them triggers or contraindications might, in any given setting, either increase our trust or increase our distrust of the relevant government actor. In addition to some of the items that you flagged, which I appreciated and will continue to think about, some folks have basically said we should rely on history, both positive and negative history. For example, Ronald Cass wrote an article basically saying, if you look at what he was something of an originalist, if you look at what motivated the framers of the First Amendment, they were thinking about 2 specific sets of government abuses: press licensing and seditious libel. And he says, all right, inductively, let's figure out what characteristics bind those together. And he came up with political self-interest and intolerance. And he said, basically, when we see those sorts of characteristics in a contemporary government setting, we should be distrustful as well. You could also apply history in a positive way, right? Where do we think actually government has done a pretty good job, a pretty competent job, right, of regulating falsity? You might maybe say the commercial marketplace. Maybe the government does a pretty good job of regulating commercial fraud or some other situations. And what's going on there? It's less politically charged, maybe, so less potential for self-interest or intolerance. Facts about the quality and the price and quality of goods and services may be more amenable to verifiability, that sort of thing. Deborah's flagged social science. Eugene has expressed his skepticism. That's another possible tool for better and for worse, right? What is the evidence on the ground for government's regulatory competence or not in any given situation?
Can I just suggest, I don't think it's so much a matter of trust whom, although I think Mark has some excellent points in his paper about when trust whom might matter. It's trust to do what? So let's just build on the example that you're giving. We trust teachers in considerable measure to decide what is true and false, just even in the process of grading, for example, right? We have to. But it's not just teachers, right? It could be the State Board of Education, which is deciding which textbook to use in the public schools. On the other hand, if the same State Board of Education said, not only do we think that textbook should not be used in the public schools, but we will forbid its use in private schools, then the government is not just acting essentially as speaker. Really, that's what the government is doing with regard to speech of its employees in K-12 schools. It is acting as regulator. And there, I think we have more concerns about it. I think there's something similar with your point about law enforcement. If law enforcement calls up a newspaper and says, don't run this story or you'll be prosecuted or arrested, clearly unconstitutional. On the other hand, they call up a newspaper and say, look, I understand you're writing the story. It jeopardizes an ongoing investigation. We know we can't stop you from doing it, but can you wait a little bit? Can you maybe omit the name of this person who might be targeted for retaliation or for killing if otherwise? And again, we want to stress we can't do anything to you, but we're just sharing our expertise, and to the extent you trust us, maybe you'll go along with it. That is, I do think, quite permissible, although it's an interesting question, by the way, where the line should be drawn. But so again, I don't think it's so much that some entities are more trustworthy than others or are more expert than others. It's that with regard to certain kinds of either non-coercive action or action that is essentially management of government resources, or especially when the government is deciding how to speak itself, we would hope the government censors its own speech and the speech of those who speak on its behalf, for example, in order to sort the true from the false. But we don't allow it to do the same in its capacity as regulator, for example, or in its capacity as manager, in maybe, interesting question, manager of a limited public forum and the like.
Actually, Eugene's answer is a nice segue also to my question, which was, I mean, I think all of you, to varying degrees, are envisaging some role in the government for the regulation of lies, but a limited role to varying degrees. And I think for both Eugene, Mark, and Helen, it's pretty narrow. Like lots and lots of the lies that are of primary political concern today would be outside of the scope of what you think is permissible for the government to regulate. But this has different implications if we think, well, the government cannot regulate these kinds of lies, but private actors may. But of course, as an empirical matter, we might think many of the pathologies and problems with government as regulator afflicts private actors as regulators too, that the government is only one of the many powerful regulators of speech in the contemporary mass public sphere. So I was curious, I mean, this panel has all been about government regulation, this is the First Amendment conference, but do the same concerns that you have expressed about government regulation of lies apply also to private actors, to private social media companies, to broadcast television, to newspapers? And if so, and if they do, then is it the case that no one can regulate these lies? That's the answer? Or is it, in fact, there's some useful distinction drawn here between government regulation, its dangers, and private regulators?
Yeah, so I mean, this is the point of contact between this conversation and your larger project, because this is a limitation on the way I think of things, but the only way I can think about that question about private entities is what public institutions are we thinking about as seeking to regulate the private entity's ability to regulate lies, okay? And then first of all, at some level, all of the concerns that we've expressed about government regulation kick in. But I have to say, on that question, and I think on that question, my priors are that there are, for reasons going to the larger project of how to develop a constitutional political economy of the sort that you envision. Short circuit's a very long argument. Basically, there should be a very large amount of discretion in legislatures to select modes of regulation of private entities on these questions. So I have no prescription for that, but whatever those folks work out I'd go with. I do want to note that the ultimate founding of my position is of a sort of generalized skepticism about the ability of courts to do a good job.
So, law by Mark Zuckerberg. I don't I don't find that a satisfying answer, right? So in response to the basic question, do I worry about it in these especially these enormously powerful private actors? Yes, I do. And I think and I'm not sure yet whether I think they're better at it than government or not. And I'm not remotely convinced actually yet that they are. But one of the reasons I can't actually give a good answer to that question is because they are vastly less transparent than government.
Right.
So initiatives like Nate Persley's initiative, there are various pieces of proposed legislation out there that would be information forcing pieces of legislation that would compel. So this notion that these are just kind of public squares and these platforms just exist to allow anybody to say what they want, I just think is a nonsensical and counterfactual reality of the way they make decisions about, algorithmic decisions and the way things get posted and so forth. They're not neutral platforms in any sense. But in what ways they are not neutral and in what ways they are in fact regulating, which they clearly are almost entirely or in critical respects still obscure. So here's a great opportunity, and forgive me, right? But I would trust the government to pass a regulation that says, disclose how it is you are making your content decisions, or right, I mean, there are all kinds of technical things we're talking about, but and that seems to me an enormously important role for government to play. Now that is, let's be clear, a government regulation of commercial speech. Like these are, Facebook and everybody else, are speakers, and boy, the current Supreme Court doctrine, I think you mentioned they're going to run into some enormous tension soon. 100% would say these people have these corporations have their own First Amendment rights. So it is clearly a speech regulation, but it is one that to me, exposes more about and better, forgive me, protects democracy, right? Than one that simply allows 1,000 flowers to bloom.
Yeah, Helen, did you want to jump in? And then
Yeah, thank you. So my answer is orthogonal to Genevieve's question, but it's inspired by Genevieve's question. It's related to Deborah's point as well. I actually think that the existence of private power is relevant to trust in government's regulation of speech, meaning once we understand trust and distrust to be comparative, we should be thinking, all right, if we don't trust the government in this regulatory setting, who are we leaving in this area? So that, yes, government is scary lots of times as a regulator, but sometimes it's not as scary as private power. And in situations where there are large asymmetries of information and or power between private speakers and listeners, that strikes me as an area that is, I am more likely to trust the government, at least comparatively, right? Not in all things, but I trust them more than the unregulated private actor.
Well, so I think Genevieve's question is an excellent one, tremendously important. I can answer it unequivocally, yes and no. Yes, we should worry about it. And yes, there are certainly some places where private entities have every right to regulate. The classic example is newspapers. If a newspaper couldn't refuse to publish something because it's false, it would be useless to me as a newspaper. One of the reasons I turn to certain newspapers over others is because I find them to be more trustworthy in sorting true from false. It's necessary for that to happen. And I think the court reflects that. And who is more powerful, a newspaper or a typical reader? A newspaper by vast amount. They're economically more powerful. Well, the ones that are still economically viable, maybe not for long, but historically they have been. They certainly have vastly more political influence than the readers. I don't think it would justify, I think the court was right in Miami Herald v. Tornillo, that doesn't justify even a right of reply, much less government regulation of what's true and what's false in newspapers, or governmental restrictions on newspapers' refusal to publish things that are false. On the other hand, imagine that my cell phone company were to say, Volokh, you're a notorious liar. You say all these things about the First Amendment. We're quite confident that they're false. What's more, it's not like we've been listening in your conversations. You have a phone line with us that you publicize as a place to call, and people, your minions are going to tell people about various things. We've called it up. It's all false. I mean, there is no such line that I'm doing. I do it all on the internet. But imagine that we're so. I think our answer would be, no. They should stay in their lane. They should be providing better cell phone service, not deciding what's true and what's false and what people communicate. And by the way, and that's in part because they're common carriers. My understanding is they're not common carriers as to text messaging. But I do think if they were to say, we're going to cancel your text message service because we think that you're spreading lies, I think there'd be a lot of pressure and quite justified in making sure that they are common carriers as to that. One reason they're not common carriers as to text messaging is you want them to be able to block spam. So, but I don't think we'd want them to be able to block things that they think are false. And it's not just even because they're monopolies, landlines are, but cell phone service is notoriously competitive. So one interesting question is, where should Facebook be as to various of its features? So maybe Facebook, when it gives you recommendations, things you might like, maybe it should be allowed or have a constitutional right to say, yeah, we hope that you like truth more than falsehood. Maybe we have our doubts, but we hope so. So we're not going to recommend things that we think are false. But maybe when it comes to whether you can keep up your page to talk to your friends and not have Facebook say, nope, you've been telling your friends these false things about COVID, so we're just going to cancel your page. Maybe they're more like the phone company in that respect. I'm not at all positive, but I do think it all depends on the particular entity, and not just based on how wealthy and powerful it is, but based on its role. To what extent do we count on it? Do we want to count on it to sort the truth from falsehood? And to what extent do we think that they're not important parts of that ecosystem? And as a result, their ability to do so is just unfair leveraging of their economic power to control political discourse.
Can I say just one?
Have the
We're
last word,
we're
yeah.
out of time, I know. So I think those observations connect up with the stuff that some of the stuff in the first panel from about creating a constitutional political economy, because I think they push in the direction of the following proposal, which is that we should be thinking about what in the discourse are called structural regulations of these entities. The standard examples are antitrust and fiduciary law, which would have to be developed incrementally from existing antitrust and fiduciary law incrementally, so as to avoid the problem of imposing a special regime for speech entities. But I think it could be done. I mean, it would be common law incremental development of these structural ideas in a way that would encompass and in some sense open up these private entities to some degree of regulation. And I actually think I don't know enough about the technology, but my guess is it wouldn't be hard to develop the idea of the text message service as a common carrier, right, with some tinkering to deal with the spam issue. I don't know enough about common carrier law to know how you do it, but my guess is you could do it without raising questions about singling out a speech entity for a special rule under common carrier law.
All right, well, thank you so much to our panelists. I think we have a lunch break now.
Thanks, everybody. We're going to break for lunch now. There are boxed lunches just outside this door. Feel free to bring it back in here to eat or perch somewhere outside. If you prefer, just please be back here right at 2 o'clock so we can get started on time. Thank you.